Greetings aspirants. Welcome to Narayana IAS. This is Ananta Krishna in this session of Daily News Analysis. We have picked up certain important articles from both Hindu as well as Indian Express. Before looking into the articles that we have chosen for today's analysis, I have one gentle plea for you all. 45 years of educational excellence is at your doorstep. In order to reap the benefits out of these services which are being rendered to you, you have to do only one simple act. Please hit the bell icon that you are seeing below and remain subscribed to our channel Narayana IAS, the one-stop destination for all of your UPSC Civil Service examination requirements. Moving ahead, we shall now look into the articles that we have chosen for today's analysis. The first article that we have chosen is from the Indian Express, which is titled A Penal Code for AI. Published on page number 11, this is dwelling into the first such regulation which has been made in order to govern artificial intelligence and its applications. Second article is again from the Indian Express, which is titled Who Bought Bonds, wherein we are trying to bring together many articles which have been published in Indian Express as well as Hindu, and we are going to come up with one singular presentation on this. The third article that we have chosen is again from the Hindu, which is titled Technology combined with behavioral analysis can prevent financial frauds, as expressed by Shaktikanta Das, Governor of RBI. Published on page number 16, it is trying to delve into some of the aspects related to concerns of consumers in the banking industry. The fourth article is from the Hindu, which is titled Army Raises First Unit to Operate Apache Attack Helicopters in Jodhpur. Published on page number 14, it is trying to give some insights into the increased capabilities of India in terms of deterrence. The fifth and final article is again from the Hindu, titled Railways Plans to Develop Multi-Modal Transport Hubs, giving a leverage to improved capabilities in terms of infrastructure in India, particularly transport. And lastly, we also have this section of practice questions where we will try to solve some of the preliminary and mains practice questions. Let's move ahead to the first article that we have chosen for today's analysis. Dear students, embark on your UPSC journey with Narayana IAS Academy. Our esteemed 5-year and 3-year integrated programs are now open for admissions in Hyderabad, Vijayawada and Nellore. Our courses include robust R&D backed initiatives such as Daily News Analysis, Daily News Review, which are comprehensive review program for a broader understanding of our day-to-day happenings, which are current affairs. Similarly, we have NCERT program, which is a foundational course that covers all the NCERT syllabi, which is crucial for UPSC preparation. We also have a mentorship program for personalized guidance, and we also have a regular test series for systematic learning and assessment of the student. So begin your journey to become a leader with Narayana IAS Academy today. Embark on this journey, make your dream come into a reality with Narayana IAS Academy. So the first article is a penal code for AI, that is artificial intelligence. This article is significant for your mains examination, where you are looking at the important aspects of governance, the requirement of transparency, and much more importantly, the requirement of accountability, particularly with respect to all those applications and utilities which are emerging out of what is referred to as artificial intelligence. This is what we are going to discuss with respect to this particular article. And this previous year question asked in 2020, the emergence of fourth industrial revolution, that is digital revolution, has initiated e-governance as an integral part of government. Discuss. Similarly, artificial intelligence is becoming an integral part of governance, and also more importantly, you might have already seen that this artificial intelligence is also posing certain risks and harms. How to regulate this and how to address these problems within the applicability of utility of artificial intelligence is the matter which is going to be discussed in this particular article. Look at this particular context. What you have seen is that the European Parliament representing the European Union has passed a law, and this particular law is the first such comprehensive law regulating the regime related to what is referred to as artificial intelligence. This has done one wonderful thing. It was able to lay down the harmonized rules, that is harmonized rules, which is referred to as Artificial Intelligence Act 2024. Most importantly, remember that laws and regulations in any jurisdiction will have to deal with the commercial applications on the one hand, but on the other hand, more importantly, it has to deal with all those aspects of these particular developments, particularly relating to the use, their applicability, their risks, and also the harms that they cause. All these are part and parcel of this regulatory framework that has been included in this particular law. Hence, this is the movement that makes it important even for India to look into how to make a regulatory framework possible within the vicinity of legal framework of India, such that AI can be utilized on the one hand and also can be regulated by addressing those risks and harms which are emerging out of it. This particular law is the, as I said, first set of comprehensive regulation related to regulation of AI in the world. Second, this is one such first regulatory regime which is enabling us to recognize and also to appreciate different levels of AI, graded levels of AI, and hence these graded levels of AI will have graded utilities, and hence they are also graded in terms of potential risks and harms. This is the second important aspect of this particular law. Third, it is intended to regulate artificial intelligence, which is having nearly this 500 million population within European Union, and hence given this scenario, it will also have its global impact, and this global impact will be related to how this particular legal provision is going to act on regulating the artificial intelligence, which is not only emanating from their own landmass but also from other legal jurisdictions. This is what makes it again important for India. Fourth, it can influence the growth and development of artificial intelligence, whereby it is also at the same time able to put the onus upon the kind of potential harm that the providers and the developers of AI can cause. It is these which were considered when this particular regulatory regime was introduced. As you see here, this is the framework which is an imaginative one, where it is able to foresee what sort of regulation that artificial intelligence requires. Artificial intelligence, in simple terms, refer to those machines which try to resolve those problems which require human-like intelligence. As you know, the human-like intelligence has 2 or 3 fundamental features. One, it is able to learn. 2, the human intelligence is able to see reason. And 3, if there is any kind of error or any kind of mistake that we assume has happened, then there is scope for correction. All these being put into one thing we refer to as human intelligence, which are the characteristic features of human intelligence. The machines are now being tried to have such intelligence such that they can solve problems just like any other human being. It is this hence requires regulation. As you see here, they have adopted a broad-based definition which makes it possible. Clearly, as you see that it is a machine-based system. Second, this machine-based system is designated to operate at varying degrees of autonomy. Why? You clearly know that it has to learn and it has to come up with its own reason or behavioral pattern, and then it has to also make certain corrections to its own behavior. This requires some sort of autonomy to function. Third, it may exhibit adaptiveness after deployment. This is the another thing. Fourth, you also see that for either explicit or implicit objectives, this infers from the input it receives in terms of the problem and how to generate output, such as it may make predictions, it may give you certain content, it may also make certain recommendation, and also it may refer you to with certain decisions. All these are the notions of intelligence that any human would possess. Finally, it can also influence, hence, both physical and virtual environments by all of these components. As you clearly see that artificial intelligence will have all these particular dimensions, which is why this has been adopted as a broad-based definition. With this broad-based definition, now it sets its broader aim through this particular regulatory framework. The European Union's AI Act says that its necessity is to improve the functioning of their own internal market. That is, the commercial aspect is what primarily they are looking at. How? By laying down this uniform legal framework, whereby particularly for the development of AI tools and their services and their applications, whereby the placing on the market, the putting into service, and also the utility of these artificial intelligence systems in the Union are being subjected to improved functioning within their own market. This is the objective. However, for having such improved functioning within the European market of this commercial aspect of artificial intelligence, the other aspects of this artificial intelligence need certain regulation. It is this which takes us to the next levels of understanding. What is its applicability now? To all the AI service providers in the European Union, irrespective of whether providers are in the EU or outside of it, for the purposes of these commercial aspects, are regulated under this particular law. Whereby, in other words, even if you are from other jurisdiction, you are subjected to this particular law. More importantly, in order to have this commercial aspect possible, in order to see the growth of artificial intelligence for the utility of the society, the AI Act 2024 of EU is trying to prohibit some of the applications of this artificial intelligence. If that system is deploying harmful and manipulative techniques, whereby these systems trying to exploit vulnerable groups with certain disabilities, whatever might be the disability, this AI system then by public authorities for their social scoring purposes, if any public authority is trying to gain popularity or more acceptance from the respective societies, in order to make sure that their sustenance is continued, their rule is continued, even in such situations. And also the third situation, where this real-time remote biometric identification systems, which is one particular application wherein in publicly accessible spaces for the purposes of law enforcement by the law enforcement agencies, if in all of these or one of these aspects there is misutilization of the artificial intelligence, then it is subjected to prohibition. For example, take the case of the third one. They may ask a particular person who is allegedly have committed some crime to, as you clearly see, the possibility of misutilizing AI has been clearly sensed on the basis of certain risks. What are they? We will see those. Whenever we are referring to those techniques where you are able to manipulate few things, we refer to it as subliminal techniques technically with respect to these techniques adopted by artificial intelligence. What are they? This use of AI may go beyond a person's consciousness. Consciousness is that a state where you are able to identify the reason for any particular action or inaction. It is in this sense, if AI is able to move beyond your consciousness and purposefully able to manipulate or deceive using certain techniques, then that particular technique is referred to as subliminal technique. Here, its objective can be to materially distort the behavior of that person in order to suit certain criminal requirements. Second, this may also appreciably impair their ability to make an informed decision by manipulating the decision making ability. Why? Your consciousness is what being hit here. Third, then this decision that you are arriving at is going to be harmful to larger section of the society, and hence these have to be prohibited. Clearly you see that the harm that is possible through AI has been recognized. Moreover, it is also talking about regulation of risk, which is what getting translated into a particular harm. So it is able to identify in graded manner what is a high risk AI system and what is a low risk AI system. The high risk AI system, as we have already seen, the one which uses those subliminal techniques in order to adversely impact the people's safety in terms of health point of view or otherwise, and also take away their fundamental rights guaranteed within their legal frameworks. Second, such AI systems hence have to comply with many requirements. For example, if that is the risk which is possible because of that AI system, then there has to be a risk management system. Second, the data that is being given by it or given to it as an input must go through lot of data training. Third, there must be transparency with regard to the applicability of such AI systems. Fourth, there is definite requirement of human oversight such that this risk can be assessed even before they are being placed within the market structures. On the other hand, you have what is referred to as limited AI risk. This limited AI risk will have a limited set of transparency obligations. For example, you have chatbots. For example, the ones which give you certain recommendations in terms of content. These are of limited risks, and these limited risks, as I said, can be subjected to limited set of transparency obligations. So the graded way in which this particular law is able to look into the dimensions of artificial intelligence makes it very significant. Moving ahead, this needs hence a governance structure. What it does is, it has created what is referred to as European Artificial Intelligence Board. Similar governance structure can also be thought of in Indian scenario. Second, its infringement whenever happens, that is the infringement of AI Act, the fine is going up to 6% of the global revenue. If you look at the level of revenue that AI companies are going to garner, 6% of global revenue is going to be a huge sum. Third, as you clearly see, the global revenue as a parameter has been taken because you cannot clearly demarcate from where these AI systems are emerging or emanating, from which legal jurisdictions they are emanating, and where its impact is going to be there in terms of such adversity, and hence global revenue is what you have to consider. Third, more importantly, given the graded way in which it has assessed the risks which are possible, similarly it is providing in a consequential and commensurate manner time that is required for these service providers and developers in order to familiarize with these regulations. So if the high risk possibility is there, then for those particular risks within 6 months they have to get familiarized with these regulations. On the other hand, for other such risks, they are also giving lot of time in order to understand what these laws are actually saying, such that the service providers and also the developers of these AI systems could incorporate these regulatory frameworks while they are coding or preparing and developing these large language models. Moving to the next article, we will look into this article titled "Who Bought Bonds?" As you clearly see in this particular image, there are a number of such news which have been presented analyzing over the list which has been published by the Election Commission of India on its website. Giving a larger context, keep in mind that India is on the cusp of or verge of a clear reform which is going to overhaul the entire aspects of the fundamental requirement of democracy referred to as election. We will look into its details. This article is important for the main examination from the perspective of whatever the significant provisions that we have pertaining to the democracy and the elections in India, and then considering this as the basic structure of the constitution, the issue is going to be at the heart of conduct of these free and fair elections. Look at these previous year questions. Clearly, as you see in this 2017 question, to enhance the quality of democracy in India, the Election Commission of India has proposed electoral reforms in 2016. What are the suggested reforms and how far are they significant to make democracy successful? Clearly, whenever you see a news related to the elections or election commission, that is going to be pertinently significant for your main examination and also preliminary examination. Second question, again in 2018, as you see now, in a row, there were number of questions which have been asked. In the light of recent controversy regarding the use of EVMs, what are the challenges before the Election Commission of India to ensure the trustworthiness of elections in India? Asked in 2018. Again, another issue that was burning in this particular year. Next question, again in 2020. There is a need for simplification of procedure for disqualification of persons found guilty of corrupt practices under the Representation of People's Act. Comment, asked in 2020. Now, as you see all these questions, clearly we can make one particular thing very clear, that elections and anything related to the reform of elections is going to be important for exam. On the other hand, as an underlying factor, if you see the third question, the disqualification must not only be applicable to an individual, but in collection also. And if you look at this collection of people that can be subjected to disqualification, it is not just about those who have already been elected, but also about those who are going to contest elections, wherein in this particular scenario, whatever the issue that is at heart of the debate as on today, that is electoral bond scheme, which provides this electoral funding to political parties, must also be considered, whereby the contesting candidates, if are found on the verge of using these funds which are of allegedly criminal nature or allegedly corrupt nature, even such candidature must also be considered invalid. However, we know that this is very difficult. It is in this sense the lack of transparency in funding of the political parties, and hence contesting the elections by such political parties is going to make these elections utterly unfair and definitely not free. We shall look into the details. As you clearly know the context, that Election Commission of India has published what is referred to as the electoral bonds related data that has been submitted by SBI in two parts. One part is giving you the list of buyers and the other part is giving you the list of beneficiary parties, and this has been published on her website. So what is the importance of this publishing? Let's look into these two pictures. As you clearly see in these two pictures, one of the political parties has gained nearly 50% of this funding. On the other hand, if you look at the entire political funding of more than 12,000 crores, if you look at this particular picture, very few parties have got benefits out of this particular funding. That means the political fray has become very skewed towards these particular political parties. This is one thing that you have to make note of. Second, as you clearly see here, these are the entities which are the top purchasers of these electoral bonds. Right from here up to here, these purchases again clearly show you the involvement of money power in the electoral politics, whereby very few individuals, if this private funding of elections and political parties is continued, are able to provide funding to these political parties, and hence elections by and large become a political field whereby it is funded by some of the very few individuals in this entire population of more than 140 crores, making these elections clearly accessible to only these individuals who are able to fund these elections. Meaning, money power is ruling the elections is what these particular two charts are clearly showing you. What do we have in terms of certain patterns as revealed by these particular two lists which have been published by Election Commission of India on her website? First one, as you clearly see, half of this funding has actually came from mere 20 donors, by which it means that mere 20 people or persons are able to purchase nearly bulk of these particular electoral bonds, by which it means that there is skewed participation in this entire process of electoral funding. The access, even though is available, clearly keep in mind that this particular anonymous nature of funding the political parties has made this clearly skewed towards very few individuals and very few persons. Second, the listed companies, such as some of the listed companies, as they are listed on this so-called Nifty 50 index, where their capital is beyond 20,000 crores, which we refer to as the blue chip companies. As they are buying, what you see as a pattern is that none of these companies have intimated about these purchases and such spending to the stock market regulator, that is SEBI. Not even this, but even they have not intimated this to their own shareholders. Given this, there is lack of disclosure, and hence disclosure of this is a mandatory requirement. Why? As per the SEBI's Act, all the capital expenditure, all the CSR expenditure must be intimated to the stock market regulator and also their board. Given this lack of disclosure clearly is showing a loophole within the SEBI Act. Hence, such funding has evaded the eyes of these regulator and hence regulatory norms. This is one loophole that this electoral bond scheme has brought out. Third, the construction companies, particularly some of the companies which have been drawing flag for their track record, either in the form of a disaster which is human made or in other such forms, shows that the persons who are charged with the criminal offences, the persons who are involved in some of the activities which are lethargic, because of which there were certain anthropogenic disasters that we have witnessed, are part of this funding of political parties. This is another issue which has been brought up by this particular disclosure. Fourth, you also see that some of the biggest donors are from the healthcare sector. On the one hand, these particular donors are facing some of the charges related to the exorbitant charges that they have claimed and mandatorily drawn from the COVID-19 infected individuals, and on the other hand, based on such complaints, these are the ones who are also going through some of the inquiries either by ED or by the CBI. Even these are part of this so-called purchases of electoral bonds. This clearly again shows you that there is lack of regulation, the necessary regulation within the health sector. Moving ahead, you also have the scenario that large number of donors are from the sectors which are more tightly regulated, such as infrastructure, and more regulated by the government, by which it means that the contracts and the licenses which are necessary to operate in such sectors are being awarded by the government. Inherently, it is being pointed out that there might be some nexus in terms of such awarding of the government to certain entities. For example, one particular entity which was part of buying these so-called electoral bonds was in fact operating over this contract of Kaleshwaram project. Moving ahead, you also have another particular pattern wherein 3 of the top 5 purchasers have purchased these bonds even as they have faced probes by Enforcement Directorate and the income tax authorities, by which it clearly means that these particular purchases are becoming corrupt, and hence such purchases are going to make these elections not free and fair. Moreover, 80% of such funding, or more than 80% of such funding, was going to a mere 4 political parties, by which the political funding and hence the political fray and consequentially even the political mandate is being influenced by this money power and is being clearly made into polarized ones. It is all these concerns which are concerning because of this electoral bond scheme, which has been brought out by the so-called disclosures as SBI has brought out through the Election Commission of India's website. There is another consequential thing that you have to keep in mind. One, If you look at the increased manner in which the participation of individuals who have become part of this legislative process, who are facing criminal charges, you can clearly see a linkage between this and this particular pattern. One, what you see is that the 2009 elections, if you look into it, in this particular election, the percentage of legislators who were facing certain criminal charges was merely 14%. If you come to the 2014 elections, it has reached to the levels of 21%. If you look at the 2018 elections, it reached to the hopping 29%, by which it means that as this data given by Association for Democratic Reforms, the participation of the individuals who are facing the criminal charges and who are also facing some of the serious criminal offences against them are becoming legislators. That means they are able to command their influence over getting the tickets, participating in the elections and making sure that they are winning the elections. So the funding of the elections through such means which is clearly anonymous in its character, through this electoral bond scheme, as it has been disclosed now by the SBI, and as you see the clear patterns that are emerging out of this analysis of these disclosures, this might be leading to the involvement of money power and hence involvement of criminality in the electoral process, and also eventually these so-called individuals with serious criminal charges are getting elected to the legislature, and eventually we also know that they are becoming part of legislative process. This is the one key concern that we have with regard to the conduct of free and fair elections and the conduct of democracy in India. Second thing, apart from this, the political party, as the Supreme Court was also pointing out, is for the purposes of the so-called Prevention of Corruption Act, can be identified as what is referred to as public servant, by which it means that as a public servant, the involvement of corruption either in the funding process or in the form of expenditure or even in the form of choosing the candidates must not be allowed, and hence as part of this particular aspect of anonymity and hence even the electoral bond scheme must be replaced with something which is more and more transparent and hence accountable. The third one, as part of Article 324, we know that the clear mandate is there for Election Commission. The superintendent's direction and control of elections in India lies with this institution, which is constitutional body referred to as Election Commission. If you refer to the superintendent's direction and control as mere expressions during the conduct of elections alone which are applicable, then it's a misnomer that you are thinking about. These are the expressions which give, according to Supreme Court, the substantial power in the hands of Election Commission, wherein it can act independently and autonomously to make sure that elections are free and fair. It is in this sense, Election Commission must hence assume larger role in making sure that such funding and hence consequentially the elections itself as a process is going to be free and fair, and hence in this direction necessary reforms are to be brought about. Moving to the next article, we will discuss this article titled Technology Combined with Behavioral Analysis Can Prevent Financial Frauds, as said by Shaktikanta Das, the RBI Governor. Yesterday being the National Consumer Rights Day, there was a conference which was held under the aegis of RBI, particularly over the functioning of the so-called RBI's Integrated Ombudsman Scheme. What is this Integrated Ombudsman Scheme is what we will be looking into, because on the sidelines of this particular conference, RBI has also released an annual report with regard to the functioning of this particular scheme. We will look into the details of the scheme from the preliminary perspective. This article is important from GS Prelims point of view under current events of national and international importance. Look at this particular previous year question. With reference to consumer rights or privileges under the provisions of law in India, which of the following statements is or are correct, asked in 2012? First one, consumers are empowered to take samples for food testing. When a consumer files a complaint in any consumer forum, no fee is required to be paid. In case of death of a consumer, his or her legal heir can file a complaint in the consumer forum on his or her behalf. Select the correct answer using the codes given below. As you clearly see, any development with regard to consumer particularly will be significant for your preliminary examination. Ombudsman scheme is one such particular aspect of addressing consumer complaints. We look at the details. As I've already told, this annual conference of RBI Ombudsman in Mumbai has been held, and this has brought into the focus the implementation of what is referred to as integrated ombudsman framework of RBI after the launch of the so-called Reserve Bank of India Integrated Ombudsman Scheme 2021. This particular scheme is integrating three fundamental ombudsman schemes that RBI already had, which were different till now. The first scheme is the Banking Ombudsman Scheme launched in 2006, particularly aimed at the banking entities. Second, the Ombudsman Scheme for non-banking financial corporations launched in 2018. As you clearly see, this is aimed at regulating what is referred to as NB and taking complaints from the consumers against these NBFCs. Third one, Ombudsman Scheme for digital transactions launched in 2019. As you clearly see, the first one is as part of this so-called Banking Regulation Act 1949. The second one has been launched as part of this RBI Act 1934, and the third one, more importantly, the Payment and Settlement Systems Act 2007, which has given this power to regulate the affairs of the consumers in relationship with whatever the digital payment system that is being evolving in India. Moving ahead, as you know that this Office of Ombudsman will look into the complaints of the consumers, number one. Number two, in this particular integrated ombudsman scheme, they will take consumer complaints, but the hallmark of this particular scheme is that would be redressed cost-free. Third, this is being defined in such a way that any deficiency in services, I repeat, any deficiency in services rendered by those entities which are regulated by RBI, that might be a bank, that might be a non-banking financial corporation, or that might be anything which is acting as an aggregator in the payment system, including even what is referred to as non-scheduled primary cooperative banks. All the entities are part of this regulatory system in the form of integrated ombudsman scheme. It is these which are being referred to as entities regulated by RBI. Suppose if there is a complaint filed by the consumer, and if it is not resolved to the satisfaction of the consumers or not replied within a period of 30 days by the regulated entity, then all these are part and parcel of this deficiency in services. It is these which will be resolved under this particular scheme. Second, in addition to integrating these three schemes, why it has been integrated? In order to make sure that consumer is free of any confusion with regard to under which scheme now I have to go for this ombudsman and get the redress of my particular complaint. So apart from integrating these three schemes, this scheme also includes, as I said, in its ambit, this so-called non-scheduled primary cooperative banks whose deposits are a size of 50 crores and above. Third one, as you clearly know that this is a clearly centralizing scheme, by which it means that the RBI is trying to adopt what is referred to as one nation, one ombudsman as a policy, as an approach, whereby this particular ombudsman mechanism is becoming jurisdiction neutral, by which it means that if I am in Hyderabad and if you are in Delhi, if I am having a complaint wherein this particular aggregator is in Delhi, then the jurisdiction becomes a matter. So irrespective of where you are located, irrespective of against whom you have the complaint, the consumer need not worry about any of these, and hence it has eased the effort that has to be put by the consumer by launching this integrated ombudsman scheme. If you are having access to the internet, then at a one click you can file your complaint as a consumer. So, looking at the advantages of this scheme, one advantage, as I already said, this has eased the effort of the consumer. He need not be worried about under which scheme I have to file a complaint, to whom I have to approach in terms of ombudsman, and 3, what is the jurisdiction that I have to keep in mind. All these have been taken away by this one particular scheme under this approach of one nation, one ombudsman. Second, as we have already seen that by defining deficiency in service as the ground for filing a complaint, whereby you are also listing out certain exclusions. Now, either any regulated entity that is regulated by RBI, whenever they receive the complaint, they cannot reject these complaints saying that this is not part of this particular ombudsman scheme. Third, it has also done away with this so-called jurisdiction of each ombudsman office that we were already seeing, easing the consumer. Fourth, in order to do all of these, what they have done is they have set up a centralizing unit in Chandigarh, whereby it will receive and initiate the process of physical and email complaints in any language, meaning there is no language barrier also. Moreover, we also have a scenario that there is one particular authority which is referred to as principal nodal officer in the rank of a general manager will be sitting, and he is the one who is responsible for representing the regulated entity and also furnishing any information, redressing the complaints which are raised by the consumers against that particular regulated entity, whereby you have clearly established an authority to redress these complaints who can take cognizance with utmost seriousness. Last but not the least, this regulated entity again will not have the right to appeal. This is very, very important. In such cases where the award is issued by the ombudsman against it for not furnishing satisfactory and timely information or documents, whereby if the institution is of lethargic one and its reply is of lethargy, and if it is not able to satisfactorily redress the complaint filed by the consumer, in such cases where it is going beyond these 30 days, also you do not have the option of even going for the appeal. So, the number of appeals because of this would also get reduced. We look into this article dealing with what is referred to as Apache attack helicopters, which are going to be stationed in Jodhpur, as this article says. This article is significant from your security perspective from GS Mains point of view, and it is also important for your preliminary examination from the current affairs of day-to-day importance. We will look into the details. Before that, let us look at this previous year question. From prelims, if you see, in 2018, this question was asked, what is terminal high altitude area defense, sometimes seen in the news? In short form, we refer to it as THAAD. It's an Israeli radar system, it's an India's indigenous anti-missile program, it's an American anti-missile system, and a defense collaboration between Japan and South Korea. As you see that, clearly this can be an important question for your preliminary examination. Second, this can also be asked in mains examination, particularly keeping in view of the fact that this Apache helicopter is part of the Indo-US defense deals. Asked in 2020, look at this question. What is the significance of Indo-US defense deals over Indo-Russian defense deals? Discuss with reference to stability in the Indo-Pacific region. These helicopters are very much suitable on the basis of the strategic position that India has in this Indo-Pacific region, making it hence important from the security perspective for your main examination. The immediate question that you see, which is how is S-400 air defense system technically superior to any other system presently available in the world, asked in 2021, also makes it possible that this helicopter system can also be asked as a mains question for your security implications. Moving ahead, look at this context. As you see that Indian Army is planning to have a station wherein this newly acquired AH-64E Apache attack helicopters will be stationed in Jodhpur, Rajasthan, within the vicinity of Pakistan, in order to bolster our stance against Pakistan. Second, this also gives us significant military preparedness in the eventuality of any kind of attack. It is in this context we are discussing this particular topic. What is this Apache helicopter? As you clearly see, it's a multi-role combat helicopter. What is this multi-role combat helicopter? You may use it for the attacking purposes, you may use it for troop transportation purposes, you may use it for cargo transportation purposes, you may also use it for even the surveillance purposes. So there are multiple roles that it can perform, and hence it is referred to as multi-role combat helicopter. And this particular multi-role combat helicopter has one significant feature. It is the world's most advanced multi-role combat helicopter, which is having the systems of lethal attacks that is possible. It is possible because these fire and forget Hellfire missiles are integrated into this combat system. Second, as you clearly see here, these particular missiles are very effective against particularly tanks and armored vehicles, giving us the due advantage in any kind of warlike situation. Third, as you see, it's about how many targets you can attack per minute, and you can clearly see that it is the highest, as you see, for any such multi-role combat helicopter, and hence this can prioritize the threats on the basis of whatever the sensor system that it has, and based on that it can provide you the significant tactical advantage in the immediate war situation. Moreover, Indian Air Force is already operating the so-called Apache fleet within this Ladakh region, keeping in view the threat perception that we have from China. Moreover, you can also look at the speed at which this particular performance can be ascertained. It can rise at a particular rate of what is referred to as the feet per minute, wherein it can rise up to 2000 feet per minute. Moreover, the maximum rate of climb can also reach up to 2800 feet per minute. This gives it hence lot of advantage over any such fleet that the other enemy nations might have. What is its significance for Indian Army? As you see that it can substantially enhance what are combat capabilities, particularly against these adversaries like Pakistan, as we have already seen. Second, as we know that it has advanced sensors and the weapon system and target acquisition systems integrated into the single entity, it can provide significant edge during the modern warfare situations. It is this which makes it very, very significant. Now, we are trying to focus upon self-reliant defense sector on the mantra of what is called as Atmanirbhar Bharat. It is this which is placing a strong emphasis on achieving this self-reliance. Moreover, you have to also recall that in 2022, we have already launched what is referred to as largest helicopter manufacturing facility at Tumkuru near Bangalore, whereby Indian Army is trying to phase out its aging what is referred to as Cheetah and Chetak helicopters over the next few years, and we want to replace them with the utility helicopters which have been produced, manufactured, and want to replace these with the new utility helicopters which have been produced in India itself, enhancing our defense capabilities on the basis of the levels of deterrence that we want to achieve against the threat perceptions from both Pakistan and China specifically. This news article published in Hindu titled Railways Plans to Develop Multi-Modal Transport Hubs. We'll look into the details. This is important from Mains GS Paper 3 Economic Development point of view, and particularly prelims from the economy point of view, and also current affairs of national and international importance. Look at this previous year question. How is efficient and affordable urban mass transport key to the rapid economic development in India? Asked in 2019, anything related to the system of transport which is an important aspect of the process of urbanization in India will become an important area for your mains and preliminary examination. Hence, this particular article that we are discussing is clearly in tune with the requirements of the examination. Look at this particular context. As we clearly know that since 2 days you are getting this particular news whereby this mega railway terminals will be established with what is referred to as multi-modal connectivity, in those cities which are being referred to as aspirational cities across the country, and these aspirational cities are being defined on the basis of population criteria which is exceeding 10 lakh. It is all of these must be remembered for your preliminary examination. Then what this multimodal transport hubs is all about? Look at this. These are serving as, importantly, the integrated junctions wherein they are connecting the other railways with various other modes of transportation, particularly the roadways, metro, bus and airways. It is this which make them the hubs of multimodal transport. Second, as a preliminary fodder, you must remember that it is the Surat railway station which will be becoming country's first multimodal transport hub, which will be ready by 2026. Third, you must also keep in mind that this multimodal transport hub which is being created is with a primary objective of promoting the rapidly occurring urbanization. We clearly know that by the time India becomes a developed country, more than 70% of the population is being expected to live in the urban areas, and hence easing the life of an individual in the urban area becomes primary for the state. And it is in this sense the connectivity and transport which is at the heart of the rapid pace at which the urbanization is occurring becomes most important aspect to be focused upon. And hence the objective here is to enhance connectivity and also to promote seamless intermodal travel. It is in this sense they are trying to reduce the congestion. The objective is to reduce congestion and also provide last mile connectivity to commuters and also cargo. Moreover, this particular multimodal transport hub will have features ranging from waiting areas, baggage handling services and also information kiosks. Moreover, they will have amenities such as escalators, elevators and also Wi-Fi connectivity, whereby they are going to ease the passengers or commuters' comfort. Given the fact that the pace at which the commutation is occurring with the introduction of what is referred to as Vande Bharat Express, we are also looking at, as part of this multimodal transport hub creation, the coaches which are having improved cleanliness and at the same time increased amenities on the railways premises as part of this multimodal hubs. Moving ahead, we also have a situation wherein the particular creation of hub will provide benefit to commuters and also cargo operators both together. How? The commuters benefit out of this, because in this any urban area what you face is the problem of either lack of connectivity or the problem of reduced connectivity. As against this, what you are seeing in this is there will be improved connectivity in order to reduce the travel time, such that the streamlining of the travel through these different modes of transport will bring ease to the commutation of an individual. Second, the cargo operators would also experience the streamlined logistics as it is pointed out, and also it will result in reduced handling cost and time, whereby the possibility of moving the goods fast enough and hence increasing the efficiency and competitiveness of the logistic operators will also occur. Along with this, there is integration of technology in the form of digital solutions, particularly for ticketing or information dissemination and the real-time tracking of the entire transport. Along with this, you also provide the apps and online portals, whereby the digital payment systems would also enhance the user experience, and not only this, in the form of information availability, information access and also the rate at which all the requirements of the commuter in order to make sure that the ease of commutation is occurring would be provided through these digital solutions. And this entire multimodal transport hubs which are being created are in clear tune with this so-called Vikasit Bharat initiative, where it is aimed at enhancing the infrastructure across the nation. What are we doing under this? There are three components which are being interlinked in this so-called Vikasit Bharat initiative. One is the sustainable development, wherein you are focusing upon environmental sustainability using the technology-driven governance and also the related progress and achievement. Second, you are also focusing upon inclusive development and hence even the so-called social welfare resulting in social development. Third, you also focus upon economic development, where you are trying to provide economic empowerment to those who are coming to these urban areas within these so-called aspirational cities, where this job creation along with this necessary infrastructure development in order to sustain this urbanization is also being catered to. We shall now move to the last component of this DNA session, that is practicing some of the preliminary and main questions. Take this first question. Answer the following statements regarding the AH-64E Apache helicopter. First statement, it is a highly advanced and lethal attack helicopter. Second, it is procured by Indian Army from France, which is a false statement. Third, it is equipped with fire and forget Hellfire missiles, enhancing its anti-armor capabilities, which is the correct statement. The first statement being correct, answer has to be 1 and 3 only, that is D. Move to the second question. Consider the following statements regarding multi-modal transport hubs. The first statement is they serve as integrated junctions connecting railways with other modes of transportation like roadways, metro, bus and airways. Second statement, Surat railway station will be the country's first multi-modal transport hub. As you see, both of these statements are correct. Now, what is the question? Which of the above statements are incorrect? So, answer has to be none of the above. Move to the third question. Consider the following statements. The first statement is Article 324 empowers Election Commission of India with the powers of superintendence, direction and control of elections in Indian territory. The first statement is correct. The second one, the Supreme Court of India recently has struck down the electoral bond scheme for funding the political parties in India on the grounds of violation of right to information guaranteed under the provisions of Article 19 of the Constitution. Which of the above statements are incorrect? We know that even the second statement is correct, hence answer has to be none of the above, that is D. Move to the fourth question. Consider the following statements. The Integrated Ombudsman Scheme provides for resolution of consumer complaints within 30 days from the date of the complaint, which is a false statement, as we know, because this comes to Ombudsman only when within 30 days that complaint is not resolved. Second, this IOS Integrated Ombudsman Scheme also governs the non-scheduled primary agricultural cooperative societies. Which of the above statements are correct? Answer has to be B, because the second statement is right. Moving to the fifth question. Look at this assertion and reasoning based question. The assertion says the Ombudsman Scheme for Digital Transactions 2019 is not integrated into the Reserve Bank of India Integrated Ombudsman Scheme 2021, which is a false statement. We know it is part of it. Second, that is reasoning. For resolution of complaints over digital payments, the jurisdiction of each Ombudsman office under the Ombudsman Scheme for Digital Transaction 2019 is defined, which is also a false statement because this has been universalized across India. There is one designated center where this is getting operationalized and also getting registered in terms of complaints. Hence, both assertion as a statement, reasoning as a statement, incorrect. Answer has to be D. That is, both A and R are incorrect. Moving to the mains practice question. Look at this particular question. Recently, this AI Act 2024 regulating artificial intelligence was passed in European Union. In light of this particular background, discuss the necessary framework that can be adopted to govern and regulate artificial intelligence in India. 250 words question, 15 marker. The answer for this particular question can be approached in this way. You can introduce by writing that there are various dimensions that this particular law is able to sensitize, identify and bring into enforcement related to the regulation of AI and also governance of AI in particular. And this is also applicable to Indian context because globally from where it is emanating we cannot specify as it is completely digital. Second, we know that in the body you can elaborate on the dimensions which are possibly discussed in this particular law, particularly with regard to the grades of risk that could identify, the harm that it could identify and also the prohibition of certain risks which are categorized as high risks and the regulatory requirements for those which are low risk category and also the time frame that it has allotted for various such risks in order to make sure that the service providers of AI and also the developers of AI are able to adapt to these new regulatory frameworks. In conclusion, you can mention the parity of the governance of AI with other such legal frameworks. For example, if I have to talk about Indian context, then I have to also look at this legal framework in USA, legal framework in European Union, legal framework in Australia or legal framework even in ASEAN, such that there is parity and also there is parity in terms of acting in coordinated manner over the influence of AI operations across the globe. It is this which makes the legal frameworks more importantly suitable for the human advancement and their progress with regard to their endeavors. I hope you have all enjoyed this particular session. If you like this video, please like, share and comment on the video and don't forget to subscribe to our channel Narayana IAS, the one-stop destination for all of your UPSC examination requirements. We'll meet again in the next session of DNA tomorrow. Thank you all.